This is the Supreme Court of India. In 2026, the court oversaw its first practical execution of passive euthanasia, finally moving the right to die with dignity from a theoretical concept into a functional medical reality. In the landmark case of Harish Rana versus Union of India, the court authorized the withdrawal of clinically assisted nutrition after 2 medical boards confirmed recovery was impossible. The patient had been in a persistent vegetative state for 13 years, suffering total quadriplegia following a catastrophic fall in 2013. By navigating the multi-tier review process that previously blocked implementation, this verdict proves that end-of-life autonomy is now a practical possibility for families across India. Under the Bharatiya Nyaya Sanhita, the law maintains a strict boundary: active euthanasia, where a doctor deliberately administers a lethal injection to end a life, remains a criminal act, classified as culpable homicide. This diagram shows the legal distinction. Passive euthanasia is strictly defined as the withholding or withdrawal of life-supporting treatment when recovery is deemed impossible, allowing death to occur naturally. This debate originated here, at KEM Hospital in Mumbai. The 42-year vegetative struggle of nurse Aruna Shanbag forced the Supreme Court to recognize passive euthanasia in 2011. The legal guidelines established through her case define the practice as a refusal to artificially prolong biological existence once the process of natural death has already begun. Individuals must execute a living will or advance directive while they are still of sound mind. When these directives were first recognized in 2018, the requirements for judicial oversight and magistrate signatures were so complex that the documents were virtually unusable in a medical crisis. This timeline shows the shift toward accessibility. In 2023, the court simplified the procedure, removing the mandatory role of the judicial magistrate and delegating authority to hospital-level medical boards. Stripping away this bureaucracy shifted the power of decision-making from the courtroom directly to the patient's chosen representatives and medical experts. Today, a living will is valid with the executor's signature, 2 witnesses, and attestation by a notary. The document only takes effect if the executor becomes terminally ill with no hope of recovery and loses the capacity to communicate their own wishes. This flowchart illustrates the validation protocol. The hospital first convenes a primary medical board of 3 experts, followed by a secondary board that includes an independent district-appointed physician. To prevent prolonged suffering, both boards must communicate their final decision within a maximum of 48 hours. Drafting a clear advance directive is now the most effective way to ensure medical boundaries are respected, legally shielding families from making agonizing life or death decisions.